During the construction of second campus in University Technology Mara or UiTM, there were cases that occurred. The plaintiff, that consists of 23 consultants, were claimed they had provided consulting services for the property for which they had not yet been paid. But the defendant rejected this claim. They state that it had no contractual relationship with any of the plaintiff. According to the UiTM as defendant, the plaintiff had been paid for their services in any cases, and there was also no loose proof. The project was then complete by using a different procedure that was awarded to parties other than the plaintiff. This meant the plaintiff would not get the full payment. The plaintiff then filed the current claim, which is whether there was a legally binding contract between the plaintiff and the defendant, and whether the plaintiff was entitled to claim herein against the defendant for all works. For the issue 1, which is whether there was a legally binding contract between the plaintiff and the defendant, we can summarize that the plaintiff claimed that they had provided a consultancy services for the property which they had not been paid yet because they were involved in the establishment and building of the defendant's second campus. The defendant disputed and claimed that it had no contractual relationship with any of the plaintiff, which include all 23 consultants. Plaintiff was also being paid for their work on behalf of the defendant. The defendant then claimed that AS Contractor was the project's main contractor. As a result, there is simply a legal binding between the defendant and AS Contractor in this matter. Unlike the plaintiff, who has been appointed as the AS Contractor main consultant and does not work for the defendant itself. Therefore, there is no legally contract between the plaintiff and the defendant.
The first solution, according to the first issue, is the plaintiff and the defendants should make a privity of contract agreement with each other. As a proof, in order for the plaintiff could approach the defendant legally for problem occurred. As an example, issue above is on payment, and the defendant might take the advantage of non-binding contractual relationship position, where the defendant denied for owing the plaintiff. This is because once there is a legal binding between them, between the plaintiff and defendant, the defendant will be fully liable on plaintiff. All claims issued by the plaintiff will not affect dispute by the defendant if both these have a privity of contract agreement or a legal binding between the plaintiff and the defendant.
The reason for this is that there is either no contract or a so-called quasi-contract. For instance, the parties may have agreed on several contractual conditions, but fail to reach an agreement on a significant aspect, such as the project's pricing.
In this case, plaintiff, which comprises of a group of 23 consultants, had done their work for satellite A, B, as well as satellite C. However, satellite C is a contract between defendant with another party, since defendant and AS contractor entered 3 separate formal contracts. Consequently, the plaintiffs misunderstood the contract terms and asked for a claim from the defendant. The defendant strictly said that their party did not owe any payment to the plaintiff, since they have no contractual link with the plaintiff for satellite C works. Therefore, the plaintiff wants to use quantum merit to claim the payment of the work that they had done. Quantum merit arises in 2 circumstances in a contract. Firstly, when the contract is silent on work done is to be remunerated or paid for the service provided. The second one is where the contract contains an express agreement to pay a reasonable sum or similar terminology.
Second solution. The defendant must pay the plaintiff a quantum merit. Quantum merit, a responsible sum that paid as much as is deserved when no contract exists or when there is doubt as to the amount due for the work done, but under conditions in which payment could be expected.
The reasoning for this is that there is an agreement to pay a decent cost for defendant services or goods. Yes, the plaintiffs agreed on a scope of work under the original contract. However, they completed the work outside the scope of the original contract. As a result, the plaintiffs will only be rewarded for the work done on Satellite A and Satellite B. Nevertheless, despite the fact that they had completed Satellite C, they would not be fully paid since none of those contracts included Satellite C.
Case study: Montes v. Smith and Trevino Construction Co. 1970. Abraham Montes began oral negotiation with Abden Perez about the improvement of his homestead in August 1968. Perez testified that Montes brought him an incomplete and unsigned contract a few times. Regardless, Perez hired the Naismith and Trevino Construction Company to work on Montes' house. Montes paid Perez $1,800, but the total value of the improvements was $3,835.
As a conclusion, increasing contractual control encourages the use of right-based negotiation strategy. Second conclusion is increasing contractual coordination encourages the use of an internet-based negotiation strategy. And lastly, it is better to have a good two-way communication to resolve the problem rather than wasting time on time-barred claim. That's all from us. Thank you.